Right, I don't have a light on my mic. There we go. I call this meeting to order. Welcome to meeting number 24 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics. Pursuant to Standing Order 1033H, the committee is studying the subject matter of the main estimates 2022-23. So I would now like to welcome our witness today, Mr. Daniel Therrien, Privacy Commissioner of Canada, who, not to preempt any of his remarks, but he will be leaving the office for in retirement shortly, and this will be our last opportunity to have him at committee. And I thank him in advance for his long service to Canada and to this committee. So. With that, we'll leave it to you, Mr. Therrien, to begin your remarks.
Thank you very much, Mr. Chair. That is very kind. Bonjour, Monsieur le Président et Madame.
Good afternoon, Mr. Chair and members of the committee. Thank you for inviting me today to discuss some of the lessons of the last 8 years and some high-level recommendations on how the law should be reformed. We are living in the fourth industrial revolution, the digital technology revolution. These technologies are disruptive. As the pandemic has shown, there can be several benefits to this, for instance, in health and education, or even in the environment. Digital technologies can indeed serve the public interest. We have also learned over the years that the consent model means of protecting privacy has serious limitations. It is neither realistic nor reasonable to ask individuals to consent to all possible uses of their data in today's complex information economy. For instance, in some circumstances where artificial intelligence is used. The balance of power is too unequal, and the asymmetry in terms of who controls personal information is too great. In fact, consent can be used to legitimize uses that, objectively, are completely unreasonable and contrary to our rights and values, and refusal to provide consent can sometimes be a disservice to the public interest. During my term, we have also seen through investigations that these technologies can present not just potential risks to privacy, but also cause real harms. For example, our Clearview AI investigation showed that the company used facial recognition technology in a way that amounted to mass surveillance. And our investigation into the RCMP's use of the Clearview technology demonstrated the growing risks posed by public-private partnerships and the absence of a legal framework governing the use of such sensitive biometric data. The Cambridge Analytica scandal, studied notably by a grand committee composed of previous members of ETHI and legislators from other countries, showed that privacy violations could lead to violations of democratic rights. Finally, our investigation into Statistics Canada revealed that a government institution believed evidence-based policymaking could justify the collection of line-by-line financial records of citizens, another form of surveillance. And this brings us to the following conclusion. While disruptive technologies have undeniable benefits, they must not be permitted to disrupt the duty of a democratic government to maintain its capacity to protect the fundamental rights and values of its citizens. What we need, then, is real regulation of digital technologies, not self-regulation. The previous bill, C-11, would have allowed more self-regulation by giving businesses almost complete freedom to set the rules by which they interact with their customers and by allowing them to set the terms of their accountability.
The last few years, we will adopt private sector privacy laws that will allow for innovation, sometimes without consent, for legitimate commercial purposes and socially beneficial ends, within a framework that protects our values and our fundamental rights. In the public sector, we also need laws that limit the state's ability to gather information about its citizens beyond that which is necessary and proportional to achieve its objectives. And overall, we need federal laws in the public and private sectors that are rights-based, that are similar and ideally, that have similar and ideally common principles for both sectors, which are based on necessity and proportionality, which are interoperable at both the national and international levels, and which give the regulator the power to audit and enforce that it needs to ensure compliance. Adopting adequate privacy legislation is not sufficient in itself. The regulator must also have adequate enforcement powers, be properly funded, and be given a regulatory discretion to manage its workload to ensure it can protect the greatest number of individuals effectively within limited resources. In July next month, the Privacy Act extension order will come into force, giving foreign nationals abroad the same right as Canadians to request access to personal information about themselves that is under the control of government institutions. Government believes that this will result in a large increase in the number of requests for access, which will trickle down to complaints to our office. So the OPC has communicated its funding needs to the government. To date, no new funding has been provided. This is a critical issue for the OPC as it requires additional funds to perform these newly mandated duties. As for the broader financial impact of law reform, we believe, based on the experience of other data protection authorities, that our budget would need to double approximately if the promised new law for the private sector were similar to the former Bill C-11. We also anticipate the expansion of advisory functions and the obligation to review industry codes of practice. We welcome these new responsibilities as they would promote compliance with the law when programs are at the design stage. Nonetheless, we are concerned that the non-discretionary nature of these activities and of our investigative work would deprive us of the ability to risk manage our caseload and give greater priority to matters of higher risk. We therefore urge you, when a bill will eventually be presented to Parliament, to give my office greater discretion to manage our caseload by selecting its advisory and investigative files to ensure we can protect the greatest number of Canadians effectively within limited resources. Not only would this allow us to operate more efficiently, we have estimated it would result in a cost saving of nearly $12 million per year. As for enforcement powers, I have consistently called for quick and effective remedies, including the power to issue orders and to impose significant monetary penalties proportional to the financial gains that businesses can make by disregarding privacy. Yet further evidence of the need for these powers was provided yesterday with the results of our investigation into Tim Hortons. Like many other data protection authorities in Canada and abroad, the OPC should also be empowered to conduct proactive audits to verify compliance with the law. The need for this was demonstrated in spades in the recent story about the Public Health Agency's use of mobility data obtained in modified form from private sector organizations. In a world where innovation requires trust, an important factor of trust in the population would be the assurance that an independent expert has their back, will verify and ensure compliance with the law, and will take appropriate action to stop or correct non-compliant behavior. Again, these are powers or authorities that a number of our provincial colleagues have in Canada and that a number of our international partners have, including in common law jurisdictions such as the United Kingdom. I would like to leave you with a few final thoughts on the future of privacy laws federally and their interoperability with the laws of other jurisdictions, both domestically and internationally. Domestically, we see that Canada's three most populous provinces have made recent proposals towards responsible innovation within a legal framework that recognizes privacy as a fundamental right. Quebec adopted such a law in 2021. All of these provinces confer order-making powers on data protection authorities, and they propose to give them the authority to impose monetary penalties directly without going through an administrative appeal, but subject to judicial review. We ask for similar powers, in part so that all Canadians, regardless of the jurisdiction, have access to quick and effective remedies if their privacy rights are violated, and in part to ensure that the OPC remains an influential and often unifying voice in the development of privacy in Canada. If the powers of provincial and the federal authority are different, if the process federally is longer than in provinces, I'm concerned that citizens will address themselves to provincial authorities and that the influence of the federal authority will become less. Sur la scène mondiale, il est aussi essentiel.
Globally, it is also essential that Canada's laws be interoperable and not too different from international norms. Some industry stakeholders say that a made-in-Canada approach has been good for the country and that a rights-based approach would hurt innovation. First, the idea that rights-based law would impede innovation is a myth. It is simply without foundation. In fact, the reverse is true. There can be no innovation without trust, and there is no trust without the protection of rights. A made-in-Canada approach that would be too different from what is becoming the international gold standard would not be in the interest of Canadian business. To the contrary, interoperable laws are in Canada's interest. In closing, my message to this committee is the following. Continue the work that you and your predecessors have been doing on these important files. As legislators, you have the power to bring meaningful change to our privacy regime, and your reports to date point in the right direction. Remember also that our laws should protect the right to privacy in its true sense, freedom from unjustified surveillance. Thus, legislation should recognize and protect the freedom to live and develop independently, free from the watchful eye of the state or surveillance capitalism. In other words, the law should protect our values and rights, hard-won over centuries, and should not be set aside in order to benefit from digital technologies. It's been an honor working with all of you. Thank you for the extra time this afternoon, and I am happy to answer any questions you might have.
Thank you, Commissioner Theriault. And yes, indeed, we to the members that may not have been wondering, yes, I allowed him whatever time he needed to make his opening statement. And with that, I want to just have a quick word about how I plan to proceed with this meeting. We started a little bit late. I want to go through certainly our first normal the round of 6 minutes each. The second round, which is Conservative, Liberal, 2.5 each to Bloc, NDP, and then back to 5 Conservative and Liberal. That would take us to about 10 to 5. I would say that I propose to do a third round if there's appetite for it. If there is not, we can suspend at that point. If there is appetite, we can continue through and should have enough time to get a third full round in, and then allow for a few minutes of committee business at the end, which we have some housekeeping items that need to be addressed. I'll be vacating the chair for a portion of that time to speak in the House. So, but I will be back in time then to take over the short committee business portion, where, like I said, we've got some housekeeping to take care of, and we'll try and get people out. I know that there are people with flights tonight too. So, with that, Mr. Couric, you have 6 minutes.
Thank you very much, Mr. Chair. And first, let me thank you, Commissioner, for your work over the last number of years and for your service to Canada. And congratulations, and I hope you are able to enjoy your upcoming retirement. Commissioner, I'm curious, and if I could ask a very broad question first, whether or not you believe that whistleblower protection laws in Canada are adequate enough.
That has not been a matter that we have experienced or applied very frequently. There are provisions in privacy laws that protect whistleblowers who wish to make complaints, for instance, either against a company or a government institution. They are extremely rarely used. In fact, I do not recall a case, so I would not be able to speak from experience on that matter.
Okay. Thank you, Commissioner. Now, I know that there's an ongoing investigation with the leak of some information from the CRA, and understanding that that there is an investigation ongoing. Could you share with this committee if you have any recommendations as to how to ensure that that whistleblowers could be protected, to ensure that when information is brought forward in the public interest, that those who might be bringing it forward are not facing repercussions?
Well, in broad terms, and I've not looked at the Privacy Act or PIPEDA in that regard recently, obviously a whistleblower should be protected. Their identity should be protected by the tribunal or the office that considers their complaints. At the same time, the complaint needs to be examined in a fair way towards the institution or organization being investigated. But I would not have anything really to say other than obviously the identity of the complainant, who's a whistleblower and who thinks that there may be reprisals, should be protected.
Okay. Thank you, Commissioner. I'm curious, with Bill S7 currently before the Senate, an act to amend the Customs Act and Pre-Clearance Act, have you had a chance to examine this piece of legislation and give advice on it?
I have, and officials of the OPC will testify on Monday before the Senate on this legislation, but we have prepared for it, so I can say a few things. Clearly, one of the areas of activity that we've examined and investigated during my mandate has been this issue of the searches of cellular devices, electronic devices at the border. There's no question that privacy interests at the border are lesser than within the country itself, which gives more latitude to border officers to search luggage, persons, electronic devices. But we have, in our investigations, underlined the fact that a cellular device, an electronic device, is not the same as a luggage or a piece of mail, that there are many more very sensitive personal information contained in an electronic device. And therefore, although we're at the border, the privacy interests of information found in an electronic device mean that these devices cannot be searched without any grounds whatsoever. So the courts have agreed with that.
Sure.
Leaving for Parliament the authority, the choice to craft a reasonable standard for border officers to perform their duties. I would simply end by saying, so I know that that Bill S7 proposes a novel standard to authorize border officers to perform their duties. At the end of the day, I would say it seems to me that no standard will stand up before the courts unless there is an objective basis for the belief by a border officer that he or she will find material that is unlawful. And because of that, I'm not so sure that reasonable grounds to suspect, which is a known standard, can really, that a law can have a standard below reasonable grounds to suspect, because the courts, it seems to me, will inevitably require some objective basis on the part of the border officer to perform the search.
So if I could ask in just a few seconds that I have left, do you believe that the bill as written then is problematic in terms of not creating an appropriate threshold then?
There's an attempt in the bill to respond to a court decision and craft a standard. I've not yet, frankly, I've heard operational issues at the border, but I've not heard arguments or evidence yet that would address the question I'm raising, which is, it seems to me the courts will require an objective basis. So I've not heard that evidence on the part of the government yet. It may exist, but I've not heard it yet.
Thank you, Commissioner.
Thank you. And now for 6 minutes, Ms. Sachs.
Thank you, Mr. Chair, and I'd like to thank Commissioner Terrien. It's good to see you again, this time in person, and to thank you in person for your service to Canadians and to all of us in parliamentarians, because as an agent of Parliament, your role is really to oversee compliance of the Privacy Act and also to promote the privacy of Canadians in the work that we do in many spaces. And, you know, in my short time here in Parliament, the digital space is one that has grown. It is being used in every parts of our lives, whether it's through these phones and particularly through COVID, you know, as our workplace environments have become our home environments as well. The issues of privacy have certainly been elevated in many aspects of our daily lives. The Minister of Justice was mandated to develop amendments to the Privacy Act, and I'd like to ask you if you support the work and what changes he should prioritize as you exit your years of service.
I should start by saying that the Department of Justice published a consultation paper, I forget exactly when, I'll say about a year ago, on potential principles for a new public sector law, and we recommended certain changes, but by and large we were fairly happy with the general tenor of the bill and its principles. One of the, if not the main issue that I think parliamentarians should think about when they consider public sector law is that because of the growing use of technology, which means a much greater ease with which both companies and government departments can collect information, it is important to ensure that technical ease is controlled by rigorous standards. And the international norm in that regard is necessity and proportionality. I think that is the main point to be made with respect to the Privacy Act.
Thank you for that. And I'd like to step off on that, if I may. You recently collaborated with 5 other countries to advance privacy in video conferencing and teleconferencing software. Can you explain what this means for ordinary Canadians, particularly in this new Zoom world? Even today, we have members of our committee who are video conferencing with us.
It's an interesting question. It speaks to the role, among other things, about the role of the OPC, not only as an investigative body, but as a body that can provide advice to companies or departments on how to comply with privacy laws. So that exercise involved, as you say, 5 data protection authorities across the world. The UK was one of them. We were one of them. And because of COVID and the greater use of platforms like Zoom, Microsoft Teams, and the like, which are extremely helpful, if not necessary, for people to communicate, work, and so on, there were certainly issues, if not concerns, as to whether these platforms protected the personal information of users properly. So rather than investigate formally whether the platforms complied with the law, we had a more informal engagement with a number of these platforms, where we were shown some of the technological the technologies being used, how they were used, and we provided certain advice to improve privacy protection. So that exercise did not lead to a stamp of approval by data protection authorities. We've looked at everything. We think everything is compliant with the law. But we thought it was still useful to have this engagement with these companies to see whether anything clearly awry was happening, which we did not see, and to try to elevate the level of privacy protection in the use of these technologies.
And I think that's really an important point. The privacy of employees working from home, particularly through these platforms, is something that's certainly of national concern to Canadians. It's something that we've even discussed here as a potential motion for a study in this committee. Sadly, not all my colleagues agreed with that. But what do you think about it? Do you think it's important that we have an exploratory search, if this is going to be the norm of technology for our employees, both in the public sector and in the private sectors, going forward, and employees need to know that their privacy is protected in their relationship with their employers when they are engaged on these platforms, and this technology is a requirement of their work. Do you have thoughts about that?
It's certainly an issue that needs to be examined. There might be jurisdictional issues as to whether this falls under provincial jurisdiction or federal jurisdiction. I will not say that is clearly not federal jurisdiction. There are companies that are under the ambit of PIPEDA, the private sector law, that play in that sector. So I'm not saying don't go there, but I'm saying if you go there, which is certainly a worthwhile issue to examine, ensure that there's federal jurisdiction.
Yes or no, a study would be worthwhile on this
Sorry?
issue?
Yes,
yes. Or no?
yes.
Yes.
On the
Thank you.
substance, yes.
Thank you. And now, Monsieur Lemieux.
Merci, Monsieur le Président. Merci pour votre...
Thank you. Thank you for welcoming me to your committee. Mr. Terrien, I would like to thank you for all that you've done during your career. I've seen you before at the Industry Committee, and I see your presentation as something with many elements, and I will work on changes that can be made. As you stated, doubling your budget is important, and we will work on that. That said, in the file on the use of mobility data by the federal government, the government informed you of its intentions, but consulted other experts as well to examine the means to depersonalize data. And so, there were perhaps moments during your mandate that you felt that you were a bit of an extra for the federal government. Answer: I felt as though there were companies and departments that were not having nightmares of being investigated by the Privacy Commission. With regards to the mobility data, the government had experts and hadn't, legally speaking, consulted on the details. Canadians don't have the information that they need, and the rules of the use of technology are so complicated. Contracts are so complex that we can't expect an average Canadian or consumer to make a complaint and that it be the usual way to reach the Commission if there is an issue. So, this brings us to proactive audits. And I believe that in order to reintroduce trust to the government for the use of data and for companies, it would be a positive thing, and it is a mechanism that exists in other jurisdictions and in some provinces. In order to ensure compliance and to reassure Canadians that their data are properly used, it would be good for the Commission to be able to do spot checks in order to ensure that there is a protection of data used by the company or a department. We could ensure that it is indeed the case. And I believe that what the government did is legal with regards to the current legislation, but it did not create a lot of trust with Canadians and consumers. So offering my office the tools to do these proactive audits, not after the fact or piecemeal, would be good. We could examine things and take into account risks and the current environment and practices that could be problematic. We could ensure that they are investigated, and we could either confirm concerns and recommend changes or order certain changes, or confirm that everything was done correctly and that Canadians can trust the process. As you know, the RCMP had licenses from Clearview AI, and in your report in February 2021, you determined that Clearview AI collected personal data of Canadians for inappropriate reasons, and that cannot be justified by the obtention of consent. Can we talk here about negligence for the use of facial recognition technology by the RCMP? Answer: I won't use the word negligence. Earlier I talked about public-private partnerships. Government and institutions work more and more with private companies, and that is normal, to help with the implementation of their programs. In this case, we're talking about the RCMP, so it's normal that a federal institution work with the private sector, but a government institution shouldn't be able to use data that it cannot collect itself. You should not be able to subcontract violations on the Privacy Act. In this case, the company had violated PIPEDA. The RCMP worked with that company, and we believe that a reasonable interpretation is that the RCMP should have verified the legality of the activities of the company that they hired. And that is true for the RCMP and for other government departments as well. Thank you, Mr. Chair.
6 minutes.
Thank you, Mr. Chair, and I want to also thank Mr. Therrien. Thanks for all of the work that you've done. I remember in 2015 with the Harper government's Bill C-51, I so appreciated your criticism and really just the commitment to upholding Canadians' privacy rights, and that has been ongoing, so thank you for your service. In your departmental plan, you indicate that your office is reviewing potential structural and operational changes. Can you describe what those changes, what they are that you're considering and what impact they might have?
I'll be glad to do that. So, Bill C-11 was tabled in the fall of 2020, as I recall. The government is announcing that a successor will be tabled in 2022, perhaps early, perhaps before the summer. So I thought it was important that the OPC start thinking about how it would be organized to inherit new responsibilities that the then Bill C-11 would have given the OPC. We don't know what the new bill will say, but there's a chance, of course, that it will have many elements of Bill C-11. So the idea is to get ahead of the curve, think about how we would exercise these responsibilities so that we're not caught off guard if the transition period, say after the adoption of the bill, is shorter than we would hope. Among the responsibilities that C11 would have given the OPC, and we think it's likely to continue to be the case, is order making, subject to appeal before a tribunal, which we think is not necessary, but still order making. And that would require, we think, the setting up of an adjudication branch of arbiters, adjudicators. Right now, we have investigators who make recommendations, but with new legislation where we would have order-making powers, we would likely need to have adjudicators somewhat distant from investigators to ensure the fairness of processes. So that is one area that we looked at. The bill also provided for a review function of codes of practice, so that's another. So all the new authorities that C11 would have given to the OPC, we have looked at, and we've given some thought to how we would exercise these responsibilities.
Thank you so much. And you also mentioned that in July, foreign nationals abroad are going to have the same rights as Canadians in terms of requesting access to personal information. And can you explain how the extension order is going to impact the operations of your office? How much of an increase in complaints do you expect to receive as a result? And then I have some questions about budgets.
So in July, I'll start with explaining what the current law is. So the Privacy Act gives Canadian citizens the right to access personal information that the government holds about them. That right does not exist for foreign nationals, except when they proceed through Canadian agents.
And just because we're quite short on time, we've got about a minute, and if you want to...
So the government expects, to cut short, the government expects that there will be a very significant volume of access requests by foreign nationals, some of them immigrants interested in their immigration status. And proportionally, there will be an increase of complaints with the OPC. So we think that there will be an important resource demand for the OPC. We have made a request to the government, which has not been denied. It's under consideration. We think it's really important to receive funding for this activity.
And you have stated that you communicated your need for increased funding to the government, yet no new funding was provided. Did the government provide a response to why they refused to increase the funding to your office? And do you feel like the federal government is responsive to the needs of your office?
For the extension order, there's not been a refusal. The request is still being studied.
And overall?
Overall, I think the issue is that we're going to inherit many new responsibilities, first under this order, then under new laws in the private sector, public sector. That's why we think we need to increase our resources significantly, probably to double them. When you look at other data protection authorities, that's generally the trend. We have had some budget increases by the government, but we definitely, with new responsibilities, we will need significant new funding.
And you had mentioned briefly about backlogs, that you had the bridge funding, and really, do you expect that there will be continued complaint backlogs going forward?
At this point, we're in a situation where, unless we're provided further funding, yes, we expect the backlogs to grow, but I'm an optimist, and with new laws, new extension order, I certainly hope that there will be some funding that will help ensure we can deal with these complaints in a timely manner.
Thank you.
Now, for up to 5 minutes, Mr. Williams.
Thank you, Mr. Chair, and through you. Mr. Therrien, thank you. I'll join the rest of the committee in thanking you for your service, sir. I'm going to start with that. You made a great statement that it's neither realistic nor reasonable to ask individuals to consent to all possible uses of their data in today's complex information economy. And you specifically mentioned AI. And while destructive technologies have undeniable benefits, they must not be permitted to disrupt the duty of democratic government to be in its capacity to protect the fundamental rights and values as a citizen. So we're going to start with a case study just to kind of go through this. And what I'd like to do is try to relate this to changes that we need to make to the C11 whenever it comes back. So yesterday you made a statement regarding mass surveillance through Canadians through the Tim Hortons app. And Canadians who downloaded this popular app, they learned that their movements are being tracked every few minutes. And you rightly pointed out that this kind of tracking can reveal to the company where people live, work, and go to school, even where they may take medical appointments. So when it comes to C11, what changes do we need to see so this doesn't happen further to Canadians?
I would refer you, I'll speak in some detail, but I would refer you to the key recommendations for a new private sector law that accompanied a letter I sent to this committee further to its study on data mobility. So there's 2 or 3 pages of specific recommendations. I'll just point the most relevant to your question. When consent is appropriate, sometimes it's not always appropriate, but when consent is appropriate, it is very important that it be meaningful. And Bill C11 removed from the law, would have removed from the law, the requirement in the current law that consumers need to have the knowledge and understanding necessary for consent to be meaningful. I think knowledge and understanding needs to be reintroduced in the law that was not in Bill C11. Also, Bill C11 allowed companies to define purposes for which they would collect information almost unfettered. Other laws provide parameters. Companies can only collect information for purposes that are, quote, specific, explicit, and legitimate. That allows the regulator to then determine whether the purposes defined by a company were indeed specific, explicit, and legitimate. Another important factor is accountability. We think that accountability in Bill C11 was defined too broadly, and it is important that corporate accountability be defined by an objective standard, i.e. Adopting procedures to comply with the law. C11 simply said, so long as companies adopt procedures, that's a demonstration of accountability. That is too subjective. The law needs to set out objective standards, such as accountability means procedures to comply with the law. In broad terms, the law should not refer to subjective standards defined by companies or departments. The law should define objective standards that are knowable by citizens and companies. Companies would have certainty through objective standards, but these objective standards could be examined by the regulator to determine whether indeed the company was accountable in such a way as to comply with the law, or whether there was sufficient consent based on knowledge and understanding by the consumer.
And thank you very much. And that's very helpful for when we move forward on trying to make that work for Canadians and for Canadian companies. Just to go back on Tim Hortons right
Just
now.
half a second.
Half a second.
Okay.
Did they perform, or did they end up stopping the tracking that they were doing based on your intervention?
So Tim Hortons application did indeed track their users' movement every few minutes of every day. I think what that shows, among other things, is that the current law, in part because it does not have penalties, in part because it does not define accountability as I've suggested, allows companies to use technology because it exists, because it may be helpful, it may be useful eventually to collect information, even though they may not have a direct use for it. So there's companies should have to, before they engage in the use of these technologies, they should be required by law to properly assess the privacy risks of that activity, and they should only collect information to the extent that it is proportionate to the uses, to their commercial objectives. Here,
Thank you.
frankly, I have a lot of difficulty seeing how it could be, other than for a telephone service provider, how it could be legitimate and proportional for a company to follow their customers every few minutes of every day.
Thank you very much. That concludes your time, Mr. Williams. I will now go to Mr. Baines for 5 minutes. Go ahead, sir.
Thank you, Madam Chair, and thank you to our witnesses for joining us today. In your submission to the Minister of Justice and Attorney General on the modernization of the Privacy Act, you indicated that you were in support of the proposed enhancements to transparency proposed in the government's discussion of paper. Would explicit transparency requirements under the Privacy Act enhance the principles of open government and public trust in government institutions?
Sorry, I did not catch the question.
Or did you miss? Okay. Can you hear me?
Yes.
Okay. I will repeat.
I heard your preamble. I did not catch the question.
Okay, so would the explicit transparency requirements under the Privacy Act enhance the principles of open government and public trust in government institutions? In your thoughts on that?
Well, sure. Transparency, openness are well-recognized privacy principles, and it would be an improvement for the law to include them. Yes.
Okay, so the departmental plan indicates you anticipate legislative changes that will grant the OPC greater enforcement powers and are preparing the office accordingly. Have you started to make those preparations? If so, what are they?
We're at the analysis and conceptual stage, obviously. We're not hiring anyone because there's no legislation that has been adopted. But I thought it would be important, again, not to be caught off guard, to think internally, how would we organize, what kind of professionals would we need to exercise this or that new responsibility, including adjudication, so that if a new legislation contains similar provisions as C11, we would have a head start and might be able to hire people, develop procedures, develop policies. One area where we intend to do some work is, again, on this question of order making and adjudication. That activity will most likely require rules of practice, which will have an impact on regulated entities who obviously will want us to act fairly in adjudicating complaints. So we have started to give some thought to what would be the adjudication process so that we can consult stakeholders as to whether we have it remotely right, and that would accelerate the adoption of these rules.
Thank you. And what progress did you make on paving the way for increased informed consent, and what are your hopes for the new commissioner in this respect?
What would be my recommendations for enhanced consent?
Yes.
Informed
consent, yeah.
So if we're talking about the private sector, I would refer you again to the 2-page key recommendations, including primarily reintroducing in the law the requirement that consent requires the consumer to have knowledge and understanding of the purposes for which the information is about to be used. So that requirement was omitted from Bill C11, and I think that's an important problem. It would not lead to meaningful consent. Yes.
Okay, and then how much time do I have Madam Chair?
You have about a minute left.
On May 16, we had the Information Commissioner at the committee, and in response to being asked about the effects of remote work on her office, she said she's very pleased and surprised the office was able to close a record-breaking 6,800 cases last year. What has been the OPC's experience with remote work, and have you had the same success as the Information Commissioner's office?
Remote work is effective. We very early after the onset of the pandemic in March 2020, we moved to a teleworking arrangement, and the vast majority of our people work remotely and effectively. This coincided for us, though, with the sunsetting of special budgets that we had to tackle a backlog of complaints. So we had almost eliminated our backlog, and it's starting to increase slightly, but we're still in a good position overall.
Thank you very much. Thank you, Mr. Baines. Monsieur Lemire, pourriez-vous commencer, s'il vous plaît?
Can you start, please? Thank you, Madam Chair. Thank you for speaking French. Mr. Terrien, during the winter and spring of 2022, the Ethics Committee conducted a study on the use of mobility data by the Government of Canada, following the comments that you sent to the committee. How urgent is it that the government examine privacy laws? So, PIPEDA and the Privacy Act. And we know that Minister Champagne was supposed to table this winter a reform for data protection. Answer: it should have happened a while ago. I believe that the government knows that there is a lack of trust in the digital sphere. That's why C11 was tabled. We had concerns with the content in the bill, but it is clear that in the public sector, the act is 40 years old, and in the private sector about 20 years, and precedes the creation of Facebook by about 5 years. So the world has completely changed since these legislations were adopted. Mr. Terrien, were you witness to action or a lack of action of the Government of Canada that had an impact on Canadian interests? Answer: the fact that there is no legislation adapted to the fourth industrial revolution creates an environment where there are potential risks, but also real harms for individuals. Would the whole affair with Tim Hortons have happened with modernized legislation? Maybe, but perhaps not. What about for Clearview? Again, the chances would have been lower. Having a strong legislation won't solve everything, but if it's rigorous enough with penalties, it is an incentive for stakeholders, companies, government institutions to respect the legislation. So, not having modern legislation created situations that were harmful to Canadians. Inaudible.
Ms. Collins, for 2.5 minutes, please go ahead.
Thank you, Madam Chair. So according to the departmental results indicator listed in the departmental plan, in the most recent fiscal year, only 45% of Canadians felt that that businesses were respecting their privacy rights. And so from your perspective, why is this number so low? The target for this indicator is 90%. and what measures need to be taken to achieve that goal? Also, do you think that that goal is achievable by the deadline of March 2023?
Probably not. Is it a realistic target to say that 90% of Canadians should have confidence that their data is appropriately protected by companies and government? I think it is. I think it is. How long that should take?
And more, what measures need to be taken in order to reach that target?
I think it's a series of measures. It starts with a law that actually protects the privacy of citizens and consumers. It starts with that. But as I say, it also requires that the regulator have appropriate resources, and I've said that I think we need to double our complement to apply the new laws that are about to come. The laws need to provide incentives for companies and departments to comply with the law. That is, in big part, what is missing currently. Technologies exist. They are attractive.
And sorry to interrupt, just because we've got such limited time. You also mentioned the need for independent proactive audits, and you mentioned it in your comments and in your introduction. Can you talk a little bit more about why this is so necessary and how it would actually improve the work of your office?
In short, because individuals are not in a position to understand and know how their information is collected and used given today's technologies. So there needs to be an independent third party like the OPC who can actually look under the hood, as we say, and do proactive audits to bring the level of confidence up, because we cannot rely only on consumers to identify issues that they complain about.
Thank you very much, Ms. Collins. We'll now go to Mr. Bazan for 5 minutes. Go ahead, sir.
Thank you, Madam Chair, and I want to congratulate and thank Commissioner Therrien for his very successful career and his service to Parliament and his service to all Canadians in the important work that his office has conducted over his tenure. Now, you said in your opening comments, Commissioner, that there can be no innovation without trust, and there's no trust without the protection of rights when you're talking about industry and industry stakeholders. And then you go on to say that interoperable laws are in Canada's interest. So as we move forward as legislators, and you quite eloquently said it is our responsibility at this committee and in the House of Commons and the Senate to develop these new laws, what is the gold standard that we should be looking at for interoperability with other countries to ensure that our businesses and industries here are competitive while protecting the privacy rights of all Canadians?
I hesitate to talk about the gold standard. So many people, when asked what is the gold standard, refer to the European Union's GDPR. It is certainly an excellent standard. There are similarities between our recommendations for law reform and the European GDPR. I would say, so it is an excellent standard. Other countries have adopted similar laws, not exactly the same law, and I'm not advocating that Canada adopt a carbon copy of the GDPR. But there are elements of the GDPR that make a lot of sense. The rights basis, proactive audits, objective standards. By the way, the GDPR is sometimes, if not often, characterized as, quote, prescriptive, i.e., adopting rules that are too minute and get in the way of commercial operations. In contrast to Canada's laws, which are principles-based, PIPEDA being principles-based, I think it is a misconception to talk of a rights-based law and as a prescriptive law. A principles-based law is in Canada's interest. We need to have tech-neutral, industry-neutral laws in the technological sector. That makes a lot of sense. In the very same way, a rights-based law protects citizens with rules that are at the same level of generality as a principles-based law, and therefore both principles-based law and rights-based law are equally adaptable and flexible to the digital world, which is a necessity with the digital world.
So we got the digital world that we have to work in, and then you also have, from the standpoint of working within Confederation. And as we know, every province is ultimately responsible for the regulation of the majority of businesses and industries, including on the privacy side. As we just saw with the investigation that you did with the privacy commissioners in other provinces on Tim Hortons and their app. So are there any laws coming in at the provincial level that we should also be looking at adapting, or should the federal government be leading and the provinces be adapting to the laws that we bring in, as you said, principle-based, to ensure that we continue to have innovation, that we aren't creating too much red tape that will hamstring our businesses here?
So at this point, the most modern law is the Quebec law, which is also a rights-based law. Some say that it is too prescriptive in some regards, for instance, in how it deals with cross-border data transfers. It may be a legitimate criticism of that law, but there are many, many elements of the recent Quebec law which I think you should be considering. I would say that Ontario, of course, has not adopted a new law, but has put out very detailed and thoughtful consultation papers on how it might regulate the private sector that is also worthwhile. And British Columbia had a parliamentary committee that issued a report along those lines. All these three provincial jurisdictions are advocating for rights-based laws.
Okay, I appreciate that. And final question, I believe I'm probably getting close to the end of my time, Madam Chair, is on the Tim Hortons investigation that you did. Quickly, how can you make sure that all of the data that they collected has been purged permanently from their databases? And also, are you aware of any other investigations being conducted against other companies that have apps that are tracking the mobility data on Canadians?
That concluded your time, Mr. Bazin, but I'll ask Monsieur Terrien if you want to answer briefly.
We have a commitment from Tim Hortons that they'll delete. If we have reason to doubt that, we can actually ensure that through technological means. And at this point, no, there is no other investigation that under our control on geolocation. We hope that the lessons of Tim Hortons will apply to other companies.
Thank you. Thank you very much. We'll now go to Ms. Sachs for 5 minutes. Go ahead, Ms. Sachs.
Thank you, Madam Chair, and thank you, Mr. Terrien. Mr. Terrien, in this room, in conversation with you, we actually talked about the notion of de-identified data in relation to PHAC. And if you could just briefly, because I have a few questions I want to ask in the time we have, provide an update on the investigation that you conducted on the de-identified data in relation to PHAC.
With respect to PHAC?
Yes.
It's still ongoing.
Okay, so no conclusions
No.
as of yet. Okay, excellent. So that takes me into more of a general question of where we're at. Given that you express yourself your support for innovation, but also with a mindfulness to its applicability in terms of privacy, and given that mobility data can improve everything from how we manage our public health and our information on how it's managed to where businesses put their shops. All of us, Google knows where I go grocery shopping weekly. The associated privacy protections that are needed to support innovation. Do you support establishing a standard for the de-identification of data? So we heard, for example, here, privacy by design and others. Do you support a set of standards for that?
Yes, with the condition that technology will change. So a standard that would be a good standard in 2022 might no longer be good in 2028. So this would need to be reassessed with technology. There might be a technology that makes re-identification in 2028 much easier, for instance. So the standard would need to evolve, I think. But the idea to have a standard is certainly appropriate, yes.
Okay, so I'm going to switch gears a little bit.
Yeah.
You know, in the day and age that we're in, I have an intern here from the Ukraine as part of the Canada Interparliamentary Program, and she showed me on her phone that she has a digital passport, her COVID passport, her essential documents, including her birth certificate and other important pieces of ID that she's able to access, which is very helpful for her when considering that, you know, she's coming from a war-torn country, documents may get lost and so on. So there's a lot of interest in the concept of digital IDs and having access to them. Could you explain how such a technology could potentially strengthen privacy security, but also potentially, you know, there are Canadians have questions about how that all could potentially work?
Digital ID, like all technologies, can be helpful, privacy protective, or harmful to privacy depending on how it is designed. So it is certainly conceivable that digital ID could enhance the verification process, the authentication process, allowing citizens to have access to services. It is certainly conceivable that digital ID would be better from a privacy perspective than SIN numbers and antiquated ways that we have to identify ourselves currently. It all depends on how the technology would be actually designed. It is certainly possible that digital ID would lead to the data to be available to many players or actors, corporate or governmental, that should not have access to all of this data. But it doesn't have to be designed that way. It could be designed in a way that provides authentication, which is the first part, and then controls correctly who in a department or who in a company has access to what information because they have a legitimate need for it.
So thank you for that. So do you think in sort of the Canadian context that we're in, and there's also obviously issue of jurisdiction, some of our identification like driver's license, OHIP cards, I'm from Ontario, our provincial jurisdiction, but at the same time we have SIN numbers, passport numbers. At the federal level, do you think it's time for us to have a deep dive as parliamentarians into how we best serve Canadians but also protect their privacy but enable them to move through this digital space with ease, but also with safety and security?
And, yes, I think digital ID is certainly an issue that has the potential to enhance access to services in a privacy protective way. It's important to design it properly, so it is entirely an issue worthy of consideration.
Mm-hmm. And have you encountered sort of international best practices in other countries? I gave Ukraine as an example, but has that come across your desk? Or?
Well, Estonia is often referred to, but it is a very small country with a very small population, but it is a model. And if need be, my office could provide other examples if you wish.
I would love some kind written outline of best practices internationally.
Sure.
Thank you. I think I'm out of time.
Thank you. Thank you very much, Ms. Sachs. Thank you, Monsieur Terrien. I put it to members. We have a couple of minutes before we have to go in camera for committee business. If there are any brief questions that members want to ask, let me know. Okay, Monsieur. So we'll just follow the same order. I'll come to you, then I'll go to the Liberal side, and then to the Bloc and NDP. Go ahead, Monsieur Carrick.
Sure. Thank you, and thank you, Commissioner. I hope this was a good way to end your distinguished service with us. You had mentioned StatsCan in your opening remarks. I just wanted to give you an opportunity to maybe elaborate a little bit more about some of the concerns that you have regarding financial information and some of the details that Stats Canada would have possibly been able to get of Canadians.
Statistics Canada is a good example leading to my answer to Ms. Sachs that the principal amendment to make to the public sector law is to have a standard of necessity and proportionality limiting the collection of information by government institutions. Statistics Canada had laudable objectives of better understanding certain problems of the poor, having access to programs. So it went about to get extremely detailed, actually line-by-line financial reports of banks and financial institutions to better understand citizens in order to give them access to better services. And in our view, we thought that this very pervasive look at financial records was not proportional and necessary. We did not say the objective was not laudable and legitimate, but there was just too much information obtained by this government institution. So we have worked since with Statistics Canada and are still working with them to improve their systems. But the main lesson, I think, is it is crucial that the standard of necessity and proportionality be incorporated in a future public sector law.
Thank you very much, Mr. Keurig. If the committee doesn't mind, I'll ask a very brief question from the chair. Monsieur Therrien, given your experience through all of this, are there any recommendations you would make to a future privacy commissioner on how to better work with government and to really address the issues of how digital governance and how technology really impacts privacy for Canadians? And if you have any advice that you would give to Canadians with respect to how they can proactively protect their own privacy in that digital space.
I've actually started a number of activities during my term for the OPC to not only do investigations of violations after the fact, but giving advice to companies and departments as they design programs to ensure that these programs comply with the law. So we've already started quite a few engagement activities with government departments, and they are more and more popular among government departments. So I would encourage the new commissioner to continue on that path. It is unquestionably much better to think about privacy. It's the privacy by design concept. It is clearly much better to think about privacy protection early in the development of a program or initiative than at the end, obviously. So we have started, and we would encourage further discussions. By the way, these discussions hopefully provide better knowledge of privacy principles on the government side, but on our side, it provides a better grounding of operational realities within which our privacy principles are to be implemented. So it's a good and useful two-way conversation to have. I'm not saying that it's always that meaningful and useful, but that could be one improvement certainly to be made. Continue these engagements and ensure that there's true dialogue between the regulated entities that we engage with and us, to be really conscious and aware of the context within which departments operate. For Canadians, stay alert, but my overall thought is, given the complexity of new technologies and business models, I'm not expecting people to read 50-page privacy policies to protect their privacy. That's why I say a regulator is not a panacea, but it is really fundamental and essential. It will not solve the problem by itself, but it is really important that citizens have an expert body like the OPC to look after them, have their back, and protect them. Yes, there are certain measures that can be taken, but there's a very important limit nowadays to how people can actually protect their privacy.
Thank you very much, Monsieur Lemire.
Merci.
Thank you, Madam Chair. And Mr. Terrien, I hope that you'll stay active and that you'll continue to work for the public interest and common interest. Perhaps as a teacher, I'd be interested in seeing your future. And I would like to talk about integrity of your mandate as commissioner. What would you like to say that has not yet been said? Answer. I'll simply, well, what I would say is that one of the things that I'm proud of is that the level of comprehension and understanding on privacy is better than it was 8 years ago for Canadians. I don't say that people are experts, but it used to be that this was a matter that only interested experts, techno geeks, people who were absolute fans, and now we're seeing that it is linked to democracy and surveillance in the case of Clearview and Tim Hortons, and privacy is important, and I think that people understand it better now. It's not a perfect understanding, but they have a better understanding than they once did. And it could bring to certain behavior changes in the population, but I'm hoping that Canadians will expect more from their government and that they will adopt laws that will protect them. I don't believe that any consumer is asking for the right to having more policies on privacy. I think that Canadians want to participate to the digital economy and receive digital services from the government in a safe manner, knowing that legislation has been adopted to protect them and that a public function was created to protect their rights. Thank you.
And last but not least, Ms. Collins, please go ahead.
Yeah, so thank you again. And my question is really, what do you see, reflecting on your past 8 years, as the biggest challenge that you faced, and what advice would you give to members of Parliament to support the next Privacy Commissioner?
I think the biggest challenge is the appeal of new technologies. New technologies can be very, very helpful and useful to society and to companies. Some companies have become extremely profitable, but they provide very helpful services. But because new technologies are appealing, cheap to use, we forget that they also create harms. And it is essential that the laws and how they are applied continue to facilitate innovation, responsible innovation, but reintroduce the idea that, so it should not be the Far West, that the internet is not a place that is not regulated. It needs to be properly regulated, but it needs to be regulated in a way where, again, the rights that we have acquired over the years, if not centuries, like privacy, are not set aside because technology is so easy, appealing, and profitable.
Thank you very much. I'll take the opportunity now to thank you, Monsieur Terrien, for your service and for coming here today to answer our questions. We wish you all the very best on behalf of this committee. Thank you again. Mr. Williams, I see that you have your hand raised. Is this...
Madam Chair, I just had one quick question, if you would allow me, just as we only have Mr. Terrien in the chair for the last time.
If you ask your question in like 30 seconds or less, we'll allow Monsieur Terrien to answer briefly. Please go ahead.
Thank you so much. Mr. Terrien, I just wanted to ask on exemptions for consent. So we had, I think C11 mentioned some exceptions for consent. And you mentioned telecommunication carriers, but what other examples have you seen for exemptions for those looking for consent from C11?
Our submission on C11 dealt with that in detail. I would say one case that comes to mind would be research, for instance. So health was mentioned earlier in this conversation. Research for health purposes could be within certain parameters, an exception to consent. C11 had exceptions to consent that were way too broad, but as I said, consent is not a panacea. It is normal that there be some exceptions to consent.
Thank you very much.
Thank you very much, Madam Chair. Appreciate it.
Thank you. Thank you again, Monsieur Terrien. We are now going to suspend for about 5 minutes as we go in camera for committee business. I haven't done that in a while.